Consider a sales manager who works for the same company for 8 years. She's a strong performer with no disciplinary issues and, regular bonuses. Then, a new senior manager joins the business. Suddenly, targets increase dramatically, and the pressure ramps up. Performance reviews, which used to be positive, now become negative. And just a few months later, the employee is dismissed for what's called capability. And this raises an important question. What does dismissal for capability actually mean in UK employment law? Because honestly, many employees hear the word capability and immediately assume it means incompetence. But legally, it's actually broader than that. Capability dismissals usually relate to situations where an employer believes someone can no longer perform their role to the required standard. That can involve poor performance, lack of qualifications, long-term sickness absence, or even physical and mental health issues affecting work. Now, here is the key point. An employer cannot usually dismiss someone for capability fairly without following a proper process first. And this is where many businesses get into trouble. Let's take poor performance as an example. Identify the issues clearly, provide support, offer training where appropriate, and give the employee a reasonable opportunity to improve. What they should not do is suddenly dismiss someone without warning after years of positive performance. Yet, that happens surprisingly often. We dealt with a case involving a senior employee who was placed on a performance improvement plan with unrealistic targets and, honestly, almost no support. 3 months later, he was dismissed for capability. The employer believed the paperwork protected them. The problem? The process itself was arguably unfair. Now, let's talk about sickness-related capability dismissals, because these are honestly extremely common. If an employee is off work long-term due to illness, employers may eventually consider whether they can continue employing that person. But before dismissal is considered, employers are usually expected to obtain medical evidence, consult with the employee, and explore alternatives, such as reasonable adjustments or phased returns. And if the illness amounts to a disability under the Equality Act 2010, the legal risks increase significantly. Another issue employees often miss is this. Capability dismissal is not the same as misconduct dismissal. Misconduct usually involves behavior, such as breaking workplace rules. Capability focuses on ability or capacity to do the role. That distinction really matters, because the legal process should look different. Now here is something important. Just because your employer says the dismissal was for capability does not automatically make it fair. Employment tribunals often look closely at whether the employer acted reasonably, whether support was offered, and whether proper procedures were followed throughout. And sometimes, capability procedures are used unfairly to push employees out quietly, particularly where relationships at work have broken down, or management simply wants someone gone. So, what should you do if you are facing a capability process? First, do not ignore meetings or warning letters. Second, keep detailed records of targets, training, support offered, and communications with management. And third, seek legal advice early, especially if the process feels rushed, unfair, or linked to illness or discrimination. At Blackstone Solicitors, based in England, we help employees facing capability dismissals, performance procedures, and workplace disputes. Because capability dismissal is not just about what your employer says, it is about whether the process and the decision were actually fair.